Hello, I'm Daniel Brown. I'm a specialist employment and discrimination barrister at 3PB, and I'm joined today by my colleague Grace Nicholls, who also happens to be a specialist employment and discrimination barrister at 3PB. Now, you may have heard that the government is proposing to change the Employment Tribunal rules of procedure. And I'm here with Grace today, who's going to tell us a bit about that.
Hi Dan, well you're quite right. The government announced a raft of changes to increase flexibility within the Employment Tribunal system, with the objective of hearing more cases, opening up court space, having a swifter resolution of claims for both employees and employers, deployment of a greater range of judicial expertise and a greater use of virtual hearings. We're talking today about the Employment Tribunal's Constitution and Rules of Procedure, Early Conciliation Exemptions and Rules of Procedure Amendment Regs 2020, which amend the 2013 and 2014 regulations.
So what were the changes made, Grace?
Sure, so I'm going to run you through about 8 of the most significant changes. It's important to say that not all of them come into force in October, so regulations 19, 20, 21 and 22 come into force on the 1st of December 2020, and the remainder come into force on the 8th of October. So change number 1 is that Regulation 3 of the 2020 regs allows for cross-deployment of judges, such as deputy district judges and circuit judges to sit in the employment tribunals. There are a number of conditions attached to this, which are set out within the regulations. Dan, what's your view about this first change to the employment tribunal rules?
Well, Grace, when I first heard about this, I recalled an experience I had of doing a discrimination case in the county court. And at trial, the judge said, I've never dealt with an Equality Act case. I don't know anything about the burden of proof. And then I also started to think, well, are we going to end up with judges dealing with unfair dismissal claims who are totally unfamiliar with the law and be in a situation where there are lots of appeals based on the suggestion that judges have substituted their own view for that of the employer, which is difficult enough for most employment judges to do consistently. There are often appeals on that ground. So do you think we're likely to see these kinds of issues in the coming months and years?
I think we may well see potentially some issues around that. The other point that I was contemplating was the idea that, a standard case in the county court is likely to be around a day, maybe a couple of days, but, never really sort of length that we see in the employment tribunals. I think in practice, this is probably going to have relatively little significance. I can't imagine that we're going to have judges coming across from other courts such as the county court and sitting on 10-day discrimination complaints. I think it's unlikely to have much significance in practice. It may well be useful for some case management hearings where the procedure is going to be quite similar to a CMC. But yeah, I can't see this having a huge amount of practical implication in reality. And of course, there are conditions attached which give a degree of certainty to parties about who will be hearing their cases. So the second change is Regulation 4, which provides for legal officers to carry out a number of functions which were typically something done by employment judges. So those include considering applications for extension of time for presenting a response, applications for an extension of time to comply with case management orders, which the parties agree to amend a claim or response, for additional information from a party, and for different claims to be considered together. Legal officers will also have the ability to consider postponements if they're made more than 7 days before the hearing date, and which all parties consent to. And finally, whether to dismiss a claim following withdrawal. I think in particular, this last one is going to have very little impact because it's simply going to be a matter of signing off on a withdrawal from a party. It's right to say that there is going to be an appropriate safeguard contained within these regulations, namely that within 14 days of the date on which a tribunal sends a notice of a decision made by a legal officer to a party, that party may apply in writing to a tribunal for that decision to be reconsidered afresh by an employment judge. So there is the safeguard there. We don't know yet about who these legal officers are going to be. Dan, what's your view on the implications this might have?
Well, I think the big question there is, as you say, who are these legal officers going to be? The quality of the individuals in terms of their training and experience is going to be very important. And also the issue of the right to request a rehearing or a decision being made afresh could just add to the administrative burden of the tribunal.
Agreed. So changes 3 to 5, I'm going to run through quite quickly because I think Dan and I both agree they're probably not going to have a huge amount of practical implication, but they are essentially to allow multiple claimants to be included on the claim form. So Rule 9 of the current ET rules reads that 2 or more claimants may make their claims on the same claim form if their claims are based on the same set of facts. Where 2 or more claimants wrongly include claims on the same claim form, this should be treated as an irregularity falling under Rule 6. So the change here from the 2020 regulations is that rather than saying based on the same set of facts, it's changed to give rise to common or related issues of fact or law, or if it's otherwise reasonable for their claims to be made on the same claim form. And we can see change number 5 is a mirroring of that principle for respondents as well. So as we were just discussing, multiple claimants probably going to be less likely than multiple respondents. But another change to Rule 16 is to allow a response form to include responses from more than one respondent or the response to more than one claim if the response or the claims give rise to a common or related issue of fact or law, or it's otherwise reasonable for the responses to be made on a single claim form. Change number 4 is an amendment to Rule 12, which deals with the rejection of claim forms for substantive defects. And there's an addition which allows a judge to accept a claim form with an error in relation to an early conciliation number, where it would not be in the interest of justice to reject the claim. Change number 6 is in relation to the inspection of witness statements. So that is under Rule 44. The rule currently reads that subject to Rule 50 and 94, any witness statement which stands as evidence in chief shall be available for inspection during the course of the hearing by members of the public attending the hearing, unless the tribunal decides that all or any part of the statement is not to be admitted as evidence, in which case the statement or that part shall not be available for inspection. Now, the 2020 regs changed this in a slightly nuanced way, which is where a hearing is conducted by electronic communication, inspection of witness statements may be otherwise than during the course of the hearing. This seems slightly ambiguous. It will be interesting to see how this one plays out in practice. There's no sort of explanation or it doesn't go any further in terms of how an inspection of a witness statement would happen if it's by electronic communication. Dan, what are your views on this change to the regulations?
I think it is ambiguous. I think it's very unlikely the tribunal will be emailing out witness statements to anyone who asks for them. So potentially parties will have to, or members of the public will have to look at witness statements on a screen, which might require, again, more tribunal staff or resources to arrange those sorts of viewings. But again, we'll await to see what is proposed in practice.
And also, if we're talking about screen sharing, it will be a case of everyone knowing how to screen share, because it's not necessarily a particularly straightforward thing. So change number 7 is a change to Rule 46 of the tribunal regulations, which deals with hearings by electronic communication. The rule currently reads that a hearing may be conducted in whole or in part by use of electronic communication, including by telephone, provided that the tribunal considers it would be just and equitable to do so, and provided that the parties and members of the public attending the hearing are able to hear what the tribunal hears and see any witness as seen by the tribunal. I'm sure all employment lawyers will have become very familiar with Rule 46 because of the COVID situation. So the amendment to Rule 46 is going to be to provide for parties or members of the public attending the hearing to see any witness as seen by the tribunal as far as practicable. So that's the change to Rule 46. Dan, presumably this simply reflects what's happening in practice. Would you agree?
Yes, that's right. My experience is that judges have been extremely reluctant to deal with any public matters such as strikeout applications or disability status issues over the phone or in a way that doesn't allow everyone to see the witness, for example. So I think this is likely to reflect what's already happening in practice in relation to the use of CVP.
And change 8, I think Dan and I again both agree this is probably likely to have relatively little significant impact, but it's that judgments for withdrawn claims are exempt from the requirement to go on the record on the register. And as I'm sure any of you watching will know, the government UK website holds all of the tribunal decisions, so both applications to withdraw and also formal written reasons and things of that nature. So this simply reflects that withdrawal claims are going to be exempt from that register. Dan, anything else you wanted to say on the tribunal rules that are coming into force in October?
No, thank you for taking us through those, Grace. It's been good to chat today.
Thanks, Dan.